The ayes are 64, the noes are 57. Part 1 as amended will stand part. The question now is that Part 2 stand part. Charles Chauvel.
Thank you, Mr Chairman. Mr Chairman, when the Lawyers and Conveyancers Act was originally passed, it made one or two significant changes to the way in which the legal profession was run in New Zealand. First of all, it recognised and conferred particular recognition on a class of practitioner who were not lawyers, but who were registered conveyancers, people who'd gained some expertise in the art of conveying property and satisfying the legal requirements in New Zealand that would be required in such circumstances. And the policy background here was to introduce some competition into the system so that the virtual monopoly that had been enjoyed by lawyers previously on this important type of work might be interrupted and prices might come down. The Lawyers and Conveyancers legislation went further. It allowed law firms and firms of conveyancers to do something that hadn't been permitted previously. Previously, there had been a requirement that these entities be partnerships and that they not be able to limit their collective liability. So basically, every act or deed done by one of these firms would be something that would result in liability for every partner in the firm and not able to be contracted out of. The legislation allowed for the incorporation of these entities. It sought to preserve the liability regime that I've described, but basically looked at ways to make them more bankable, for want of a better way of describing it. And there are a couple of sensible machinery amendments in Part 2 of this legislation that are consequent on those changes. They relate to the position of the estates, the wills, the trusts of those who have become involved in conveyancing practitioner incorporated firms or in law firms that are incorporated as a trustee of a trust in which each beneficiary is a relative of one or more of the trustees, and each trustee is a conveyancing practitioner, in the case of the registered practitioners, or as a lawyer, actively involved in the provision of the body corporate of regulated services. So they're sensible changes, sir. There are also changes to the disciplinary regime that apply to lawyers. Applications for a review by the Legal Complaints Review Officer of a particular decision or action of a standards committee will have to be lodged within a 30-day working period, commencing on the day after a copy or notice of the decision or action is brought to the applicant's attention. We've always said that we support these amendments. They are sensible. It's just a shame that while we will be voting for this part, because of the provisions that are contained in Part 1, to which we take strong exception, we will be voting against the bill as a whole.
No further calls. I'll put the question. The question is that the Minister's amendment set out on SOP number 136 be agreed to. Those of that opinion will say aye. Contrary, no. The ayes have it. The question now is that Part 2, as amended, stand part. Those of that opinion will say aye. Contrary, no. The ayes have it. The question is that clauses 1 to 3 stand part. Is some member seeking the call? Charles Chauvel.